All right. Hello, Lyric Armstrong, your real estate agent and advocate. All right, we are here. And like I said, I wanted to get into different different courts to give different perspective on real estate. And today we're going to look at a probate matter out of Lenawee County. And so very grateful for them bringing this matter forth. Now, in this understanding, this is a probate matter, but some of the things that come out could actually be of interest to you, even if you have a trust. So we've talked before about having a trust. You can have someone designated to operate and to fulfill the goals of your trust, making sure that the money goes where it needs to go, that the property is handled appropriately. A lot of times you'll have the executors that will go through and itemize your items and determine, if you're going to have a sale of items, they'll have the appraiser come through and appraise different things, and then you'll do an estate sale, and then they'll take the funds from that and distribute it in an appropriate manner based upon what you have put in your will that you want to happen with the money, whether it's a complete equalized split among beneficiaries, or if you have certain personal items that go to certain personal individuals, or you can also do it to a church, whatever you want, any nonprofit or for-profit company, whatever you decide, because it in fact is yours. So you can do with it as you please. So there aren't any limitations on how you can do it. Obviously, you can't do anything that's going to be considered criminal activity, but outside of that, you can do whatever you want with it. Well, it's a very quick process. You have between 30 to 90 days to get those things completed. And I trust because you have things already covered in a place that they're supposed to be. And it's just a matter of, issuing the letters, doing some administrative duties to get things accomplished. And it should be relatively quick, maybe 6 months, depending on if you have multiple houses that need to be itemized and different estate sales that need to happen, and you do it as a strategic thing to wait to put things up for sale because you think the market's going to be better, or it's the summertime and people are going to want to actually get out the house. That's very much important when you're talking about houses that are in season sensitive locations, right? I'm in California, Southern California, so we kind of have decent weather throughout the year, so we don't really have a defined season pattern. But if you're talking about somewhere where it snows in the wintertime, the last thing you want to do is have an estate sale during the wintertime, because who cares about China? No one's coming out to go buy China. So you might want to wait and get a petition that you can wait until the summer when people are out and about and able to really maneuver and come and drive by and see your estate sale, right? So that may have some time constraints just depending on strategy. But reality is, when it comes down to the law, it does not take long to administer and to effectuate the different requests and necessary steps with regards to a trust. Whereas when you're going through probate, it typically is that you have a will and no trust, or no will at all. And the court is trying to figure out what to do. Well, this particular case has a very interesting set of facts. There are a few beneficiaries, and consequently, they are represented. I think almost every beneficiary has their own attorney. So I think there's like 6 attorneys here, and there are some businesses. So when you think of a trust, you may think, oh, well, my jewelry, my fur, my cars, my vintage cars, my houses, those are all great, but that's not the only thing. Anything that you have of value, any asset that you own, shares in stock, your vacation homes, of course, and businesses you can put in a trust. So there are businesses that are being accounted for in this trust, and some pretty big named businesses. And the beneficiaries are taking issue with some of the accounting. And this is a part of why when you have someone that's going to work your trust, you want them to have some type of knowledge that you can support them being the one to run your life. So let me put it to you this way. If you were still alive and you would not trust your cousin with your checkbook, then don't trust them to be the administrator of your trust, right? because in essence, you're giving them the power to it all. And hopefully they are doing right and following the law and not being nefarious in any way. But there also are companies that will bond the administrator so that if something financially is improperly done, they will cover it. And so you can get those type of insurances as well. Well, this case is diving into, are people getting paid? How much are they getting paid? How is this payment being done? And what the account is supposed to be versus what it is, and who's supposed to be on the account versus what's going on. So these are some of the things that come into play, not just probate wise, but also for trust wise. When you have a very complicated trust, when you have high valued assets and things that have, you know, payroll and different trust checks that need to go out, like interest bearing checks and things of that nature. You want to make sure that the person that's dealing with that, the responsible party, the administrator, is well informed. And there's a part in this trial that I get a little concerned by some of the representation. So let's come and see what's going on. I know there was a long intro, but hopefully this helps to set the scene, because this is a different way of looking at real estate and even looking at probate matters. We haven't done this in the past. So I just wanted to give you a little heads up on it. Make sure you can hear. Okay, you can hear. We are, like I said, let me get this courthouse. Oh, like, share, and subscribe.
Right, we are on the record.
Make sure you like, share, and subscribe. So let me do the same thing. I'm going to subscribe and like. We need to get this up, because anything that's teaching us that it's going to benefit us, the heirs of our own trust for our generation, they deserve a share and a thumbs up, okay? And a like, a subscription. We can do that. So make sure you do it for this channel, and I just took care of my housekeeping and did it for that channel.
With regard to this file, this is a review hearing. There have been a number of documents submitted to the court and circulated amongst the attorneys.
Oh, wait, we might be going a little fast. Yeah, let me turn it
that did result
to normal.
In contempt last week. So I have invited the attorneys here this afternoon to be heard on.
Everyone knows to be held in contempt means to violate an order of the court. Okay, so let's go back. She's talking about a contempt hearing. So let's see what is going on here.
All right, we are on the record with regard to this file. This is a review hearing. There have been a number of documents submitted to the court and circulated amongst the attorneys around the attempts to comply with the court's order that did result in the contempt last week.
Okay, so looks like the court ordered for some documents to be produced, basically, and sometime last week prior to this hearing, and they weren't done, so people were held in contempt. And now we're having a review hearing to say, look, Your Honor, we have produced the documents, in fact, so please take us out of contempt. That's the way I hear it.
I invited the attorneys here this afternoon to be heard on the issue of whether or not the documents that we have received at this point are in compliance with the court's order.
Okay, this can happen in almost any type of case. Motion to compel hearings are really centered around production, right? So it's a discoverable situation where you need certain things produced from one party to another and vice versa. And whenever you produce to one party, you copy every other party. So if you have more than one party, everyone gets a copy. And that's a discovery element that happens outside of court. But then if you feel like a party is being non-responsive, or they're holding back certain production, or, you know, they're redacting everything and you can't see anything that's necessary, because redaction is only specific to, you know, pertinent confidential items, then you go before the court with a motion to compel. The court will say, okay, I've issued this order. If you fail to comply with that order in totality, then you bring it back up to the court and say, okay, you compelled them to do this. You gave them an order to produce and they have not done this production. Then you can find yourself in contempt, or you can find yourself sanctioned. So not sure if that's the complete flow of how this happened, but what the judge has represented at this time is that there was a motion to, there was an order put before the court, and now they're trying to verify if there's compliance, because they were found in contempt for not complying in the past.
We have the names of our participants, please. Let's begin in the courtroom.
Suzanne Welcome, guardian ad litem for Angelina Warner.
Michael McFarland, attorney guardian ad litem for Dee Warner. Mary Lee on behalf of Dale Warner and Mark Westbrook.
Good afternoon, Your Honor. John Folderman on behalf of the successor conservator, Charles Bullock.
Charles Bullock, the successor conservator.
Good afternoon, Your Honor. Ariel Berger here on behalf of Dee Ann Warner.
Okay, so real quick on housekeeping things. This may be your first time. Try to unplug if you can, or turn your volume down, because I'm going to try to keep our volume up. There are variances in terms of who has a good mic and who's not. And in the courthouse, I think that they're sharing a mic, or if they're not, maybe the gentleman's mic is off, but he's very low. So I'm going to try to keep the volume up so we can hear what he says.
Thank you. And we have made.
You're welcome, Your Honor.
Provisions for Mr. Weisberg and Mr. Warner to be present with us from the jail. So would you, there they are. Would you like to give us your names, please, for the record?
Mark Weisberg.
Dale Warner.
All right, so sorry. I hope you guys can hear me. And sorry if I cleared my throat in your ear. I'm so sorry. I thought I pressed mute. But anyway, so we have both of our gentlemen are in jail. And I think it's because of the contempt charge. I don't know. But that's interesting that two of them are. So just
Thank you. All right,
Just
Mr.
taking
Lee,
note
would
of
you like
that.
to give us a short introduction of a summary of what you have supplied so far?
it seems like everyone takes into question.
I can review what I have here, but you
His-
only supplied it, so I figure it might be best to ask you to go ahead and summarize that.
Yeah, his representation of what the accounting is. So
Yes, Your Honor. Good afternoon. Larry Lee on behalf of Mark Weisberg and Dale Warner. Pursuant to the court's order last Wednesday, we have produced everything that was contained within the judgment of contempt. That would be the budgets for all farming operations, supporting documents for the same, and grain mill checks. I have supplied the court with items specifically produced in the last 2 days since the judgment of contempt was entered. The documents include Dale Warner, DBA Warning Farms budgets for August, September, and October 2023, grain check stubs from July 2022 through current. The reason for the stubs as opposed to the actual checks is they're not available, but they will be ordered from the bank to be produced. The stubs were sufficient.
okay, so you know what a stub is, but the courts typically like to see the check, the endorsed check, the cleared check from the bank, because it has all of the accounting information that lets you know that this check actually did get paid out. Whereas you can write up a check and then destroy the check and hold the stub and be like, look, I paid this. This is important accounting. If you are an administrator of a trust or of any type of accounting business, accountant or bookkeeper, even if you're not a CPA, accounting is extremely important to maintain records. They're talking about 2022, so that's a little over a year ago. That's not old enough for destruction, but I like to keep my records for extended time. So once you get past the 7 years, then I just put them on electronic form, put them on USB for another 3 years. So I can keep them for a whole 10, because you just never know when you're going to have to produce, right? Now you can always fall and say, you know, it's after the 7-year timeline. So obviously they're destroyed and you just show the destruction sheet and you can prove it that way. That's perfectly legit. But I just like to keep mine a little extra in time just in case. This particular attorney is representing, I guess, the two gentlemen who are in jail at this time, Mr. Warner and Leisberger, I think is what he said their names are. And he's representing the different payouts. And this is important because if you are taking on the role as an administrator, you may want to sit down, you know, with that individual, see what all of their accounting is long before. You might want to interview a couple of people in your family to decide who would be most responsible and able to take on the job of being the administrator of your trust. It can be a short period of time, it doesn't have to be 6 months or longer. It could be 90 days. But whatever the time frame is, you want them to obviously have the credit that's going to pass the court inspection, that they don't have any felonies on their record, even the ones that didn't tell you about, no judgment, but just got to make sure that they're clear, because the court will find out and kick them off if they are not able to pass the background. And you also want to make sure that they understand bookkeeping and how to, input in QuickBooks or whatever program is necessary so that they can prove that things are getting paid. Because one of the responsibilities is to ensure that you don't lose any property prior to the transfer of title, right? And that can be easily done if you are not paying the bills and not paying attention to any liens or taxes or whatever have you. So
Dale Warner, DBA.
Want to make sure that they're qualified.
Supporting documents from September 2022 through July 2023. Dale Warner, DBA Warwick Farms, AP, which is aging summary and supporting documents. Dale Warner, DBA Warwick Farms, bank statements from September 22nd through July 2023. Dale Warner, DBA Warwick Farms Services, bank statements from September 2022 through July 2023. Smile Mile Transportation LLC, bank statements from April 23rd through July 2023. There was a fraud that occurred in March of 2023, so they had to create a new bank account. The successor conservator and his attorney are aware of that. As such, we do not have access to the older statements prior to April of 2023. Smile Mile Transportation LLC invoice list and details. They wanted a copy of the Bader trailer security agreement along with a note, secured that. Laidlaw rental agreement, the Laidlaw rental agreement extension. In addition to this, we produced invoices for Laidlaw. All of the QuickBooks documents for all of the Warner companies were produced back in March, but we have verified that there were transmittals signed by Mr. Polderman's office. They have all the QuickBook downloads along with any of the codes. If they don't have the codes, we're happy to provide them. As I've mentioned many times, there's an open invitation to come to the Warner offices to view any and all documents and any and all items that they would like. There's a number of other things that were requested outside of that escape me in the moment, but pretty substantial list. As it relates to the judgment of contempt, the 3 items that the court wanted were produced last Thursday.
Thank you. Those documents were circulated to all counsel?
They were with proofs of service, Judge.
Thank you. All right, let's go, Mr.
In addition to all counsel, also the parties have obviously copies of it as well.
Call your cable company and cancel your subscription. This new groundbreaking
Judge.
Thank you. All right, let's go, Mr.
In addition to all counsel, also the parties have obviously copies of it as well. They were submitted in the form of Google documents with an open transfer, meaning any one of them could have downloaded them. The financial documents were also redacted, so that it would protect the names and identification of the various entities.
Let's go.
Okay, so we talked about a redaction like for half a second earlier, and I don't know that we actually gave true definition. Some may be already familiarized because you may find yourself as a law nerd, right? So you have a concept, but just for general public, just real quick, redaction is the removal of certain information. And in the law, there are particular pieces of information that must be redacted from documents before you produce it to the other side, before you give it to the other side in discovery. Usually it's like the first few numbers of an account, the last 4 digits stay, social security numbers are removed. I actually removed them all and just and you have to put the word redacted there so that people know that something has been removed in case it comes into question if it's something that should be removed. And then like driver's license ID numbers have to be redacted, birth dates redacted, things like that. And the reason comes into play is because once you give it to the other side has the option of doing a motion to compel, like we talked about, which is a publicized document. So you don't want to have confidential sensitive information put on the public domain once they file a motion. So if you're producing a document, typically you will redact those sensitive pieces of information. And then if that information is deemed important or necessary, then the other side will do a motion to compel it. And then you can maybe do a motion to have it, filed under seal or something like that to give protection away from the public. He's speaking that those particular information was redacted as under normal practices. And other than that, all sides are supposed to have the documentation on hand, is what he's representing to the court at this time.
Go to Mr. Folderman.
Good afternoon, Your Honor. I have had a chance to review those documents. The one item that I'm not seeing, and I had emailed Mr. Lee just before the hearing, I'm not seeing any of the Laidlaw invoices. So if those have been produced, I'd ask that you direct me to those because
Laidlaw is a company. Okay, so don't get confused with Laidlaw. I think it's another transportation company. It sounds like these are transportation companies, but Laidlaw is a company itself. It has nothing to do with a particular law that was passed.
I have not seen actual invoices either to or from Laidlaw for trucking services. I see deposits into the bank account, a substantial amount of deposits into the Smile a Mile bank account, but I have not seen those invoices. Now, there's probably been 7 or 8 emails from Mr. Lee, as well as the Warner children, the Google Dropbox. So, but I haven't seen it. So if it has been produced, if he could direct me to that, I would appreciate it. But I don't have that as I sit here today. Also, with respect to the passwords to QuickBooks or to Intuit, that would be helpful as well. I do not have passwords to the online system. I believe the data is in the cloud, so I should be able to access that from my computer. So I'd also like the password so we can avoid these exercises in the future. And I also note that the court order provided that all of the funds were supposed to go into a Premier bank account. In fact, right now, all of the funds, whether it's Smile a Mile or Dale Warner DBA, those are all going into accounts controlled only by Dale Warner and at Old National Bank. So I'll leave it to the courts. I mean, if Dale Warner is going to be setting up these new accounts or using the existing Premier bank accounts, and Mr. Bullock needs to be added to those accounts, we need to have optics on those. Mr. Warner may have a difficulty in doing that from jail, but Mr. Bullock should be on those accounts and they should be at Premier Bank as was provided in this court's order from last fall. That will also, in theory, avoid continued requests for information or any sort of gamesmanship if we have access to the accounts and we can see it in real time. We do have a number of questions. I don't think they're necessarily front and center for this review hearing. For example, the lease that allows Laidlaw to occupy the property was with DDW Transportation or Smile a Mile, and they don't own any real property. It's a lease with an entity that doesn't own any real estate. It should be with buyback. So this in no way resolves all the questions. I do think, though, with the exception of the Laidlaw invoices, which I don't have, and the lack of deposits into the bank account, the other information is supporting documentation. It does include bank statements and it does include an operating budget.
Okay, I'm confused about attorney John Polderman. He just represented that the company has a lease with another company that doesn't own any real property. That's odd, unless the only time that that would make sense is if the lease that they have with the company, that company is like a property management company. So they may not own the property themselves, but they have a contract to operate as property managers, and they can go ahead and license with the tenants for I'm not license, I'm lease lease with the tenants so that they can rent the property out. But usually your rental agreement stays with the owner. So I mean, I guess there would be okay to allow the property management company to go into contract with a tenant directly. The only reason why I'm conscious of that is because what happens if you change property management companies? You know, you don't necessarily want to change tenants, but you don't like this property management company and you want a new company. Now everyone has to sign a new agreement. So I wouldn't think that would be best practice, but you can give a third entity the right to enter into contract on your behalf under certain conditions. So you can do that. Maybe that's what he's speaking of, but it would be very odd. And it would be something to call out in terms of an accounting issue is if you have a financial relationship with an entity that doesn't have the power to give you something in return. So it would make it look like you're just moving money around, right? Because if you're saying I'm leasing from a property, from a company that doesn't own any real property in the area, well, what are you leasing from them? You could be leasing equipment, but that too, they would need to be the owners of the equipment. You would need to have a contract and stuff that say that. So it does bear to question to like what is going on with that particular contract,
But I believe those.
if that's what he's talking about.
Watch 100 plus.
But it does include bank statements and it does include an operating budget, but I believe those two items are still open.
Would you like to respond to that?
Sure. We have produced the late line invoices. Mr. Polderman and Cammy Warner, who's Dale Warner's daughter, had a conversation last week about it. He was concerned about any invoice that was over $500. She and her sister spent almost 24 hours between Friday and Saturday.
Who are those
copying and
people?
producing those documents.
I don't like when people answer a question in a roundabout way. If you want to add more pertinent, salient arguments and information of fact that's necessary, do that. But answer the question first and then start adding in your extras. Because like these are naming people's sisters and they came and looked at invoices and John Polderman, I could have sworn, I don't know that he had any representation of the sisters, but nonetheless, the question is, he doesn't have access to these documents. Where are they?
Which were sent. I don't know why Mr. Polderman doesn't have them, but we'll certainly get them to him.
Were
Okay.
they physically sent or were they uploaded to the virtual?
They were
tool?
uploaded. I mean, there's literally thousands of documents, Judge. They were uploaded to the Google Docs folder and emailed. Not just.
That too works my nerves. I ask you a question, give me an answer. Don't come snippetly. Well, there's thousands of documents. I don't care if there's 2 documents. Where are they located? And trust me, I have produced thousands of documents in paper form. So that's not abnormal in a production world of litigation. And it's done. So the question is, where are they? How were they produced? Physically or uploaded? And so if there's uploaded and he's having a problem getting into the upload, then maybe you need to put it on a disk for him, but don't get snippy.
Mr. Polderman, but everyone else. So if he doesn't have them, we'll
That's
make
just
sure he
me.
has them.
Right. Are you also willing to supply the online login for the QuickBooks so that the conservator can access the real-time information contained in there for the companies concerned?
Yes.
And
That's never been denied before, Judge. In fact, Russ Dempsey was given the QuickBooks logins, came to the office, downloaded what he needed to download. We offered it this.
Okay, so this attorney is kind of a little irritating to me because he's very interested in getting a set of facts that kind of go around the question. I do like the fact that he did answer the question up front and then start adding his facts after, but it's almost as if to say Attorney Polderman is bringing an issue that really is not an issue, when it's been clear that he doesn't have the access, like he's representing he doesn't have the access. I'm concerned while this particular attorney at the podium did not confirm that everyone has received the documents when his clients have been held in contempt for not producing them. I mean, you're on court saying, this is all the things that I produced, and these are all the things I gave them access to. And no one called them and said, hey, did you get the link? Hey, are you able to get in? Do you see all of the documents? Okay, we're going to court now to prove that we've given them to you. Like, that's just simple, like, I don't understand.
Same thing to Mr.
Like, that's simple follow through. You want to make sure that they receive it on the other end before you get up before the judge talking about all the things you've done. Because now you come up being snippy talking about, oh, it's never been a problem. Oh, that's never been a problem. Clearly it is a problem. Somebody got in contempt for not producing something some kind of way.
Well, like Mr. Polderman.
Because it's a problem.
And it's never been taken advantage of. We supplied them the QuickBooks documents, as I said, in March of this year. But no, it's not a secret. They can come to the office anytime they want. We'd love to have them and be able to show them what is there.
He doesn't want to come to your
Mr.
office.
Polderman, I think, is asking is that the access to the online.
I do not want to pay my attorney to drive to your office to see the documents that are online. What are you talking about? He doesn't want to come to your office. What do you need to come to your office for? You just said you put them online. He wants access.
So that he doesn't have to physically come to the office.
No problem, Judge. There's no gamesmanship here. We're transparent and we are willing to produce whatever needs to be produced.
He is laying that on so thick. I'm sorry, I keep pausing, but he's really getting underneath my skin. He's laying that on so thick. He's giving me the impression like you're putting too much extra on it. And like I said, it could be because his clients have been found in contempt. Maybe that's the reason why he's hammering so hard on their transparency and their character and their credibility in this matter. But like I said, you could have avoided the look of anything nefarious if you would have made simple phone calls and emails to everyone and said, here's the link, please confirm you've received it, please confirm that you have been able to gain the proper access and see all the documents there. We've had them uploaded. So that when you get to court and say, well, I emailed him 3 days ago twice and he hasn't responded, so I'm not sure if something's wrong with his server, but I have reached out to confirm his receipt. At least it shows that you were making the attempts. At this point, you're just giving me a whole bunch of excuses and claims that it's never been a problem, but the court does not take issue for no reason at all. The courts do not want to intervene, and they don't want to intervene in discovery. They don't want to intervene in the matter. They really love it when you guys work it out on your own. So if this judge put in an order and then found someone in contempt for non-production or not following the order, all of these statements of, oh, that's never been a problem. Oh, that's never been that. There has been a problem. They didn't just do it just because she woke up one morning and she didn't like your tie. Like, obviously there was a problem. So stop with the bantering.
Many of these documents have been previously produced. I gather Mr. Polderman's office is very large, full of documents because Mr. Weisberg.
What is this statement? Mr. Polderman's office is very large, full of documents. What? There is a lot of backstory we must not know. They must be fighting a great deal about documents. And trust me, they do. We do. Okay. We fight over the documents, the production of documents, the non-production of documents. You know, what documents should you have versus which documents you say you have, and why don't you have these other documents? We get into it over our discovery because discovery is a major part of the case. It helps us to discern what's going on. and what's provable. But he is like, everyone has massive amounts of documents, Your Honor. You lost, okay? You lost. Whatever the motion was, whatever that hearing, you lost it. Stop trying to relitigate that factor and just answer the questions as presented.
Has been there.
This is annoying.
Dropped off documents, got transmittals for them. They've been produced for this office, for your office as well, pursuant to other pleadings in this.
Look
court.
at her face. The
So
judge is
we're-
like
yes,
not,
we'll
she's
produce
so like,
whatever the court asks.
How do you propose to remedy the discovery that
I love her. I don't know this judge, but I love her. She's like not moved. He has gone through a whole soliloquy. He's gone through a whole soliloquy based on how the documents have been produced for months on end, and there are thousands of documents, and everyone has the documents, and it's absurd that documents are missing, and there's no nefarious gamemanship happening. And she's like, look, how do you want to address this discovery? She's not even entertaining him. It's almost as if he's not saying anything. Womp,
So
womp,
yes,
womp.
we'll produce whatever the court's asking us to do.
How do you propose to remedy the discovery that the accounts that were supposed to be receiving the proceeds from the farming operation are not being used, and rather that those funds are going into accounts that are solely held and operated under Mr. Warner's name individually?
I'm not sure that that was ever the case. We're happy to put the monies in whatever accounts Mr. Bullock and Mr. Holderman would like it to. I mean, part of the agreement.
You see this face? You see this face? I have the same feeling because this man, Mr. Polderman, said, Your Honor put this honor here. Your Honor put in a order for the accounts to be into a premier bank account with, XYZ names on it, and it's not happening. And she just says, how are you going to remedy this? We need to get this figured out. All these documents that he started talking about just went right out the window. She let him have his day in court with all that piece of information that's nonsensical to the matter at hand, because it's not truly factual to her order, obviously. And his response is like, oh, well, I don't know what you want me to do. I guess we can do it that way. She put an order in. So if I were these litigants and this was my representation, I would start thinking about some other representation. Because if the judge is giving orders and placing instructions that she wants done, there is no 2-3 days later, 2-3 weeks later, do what the judge said. She doesn't need to issue a whole new order. And if she's already told you she wants it in one premier bank or premier bank account, then that's where it goes. So your answer should be, Your Honor, we understand the order is to have it in the account of the premier bank and have all individuals on the bank. Considering my client is in jail, he's not in position at this time to go down to the bank and have it changed. But as soon as he is released, whether it's this client or that client, as soon as he's released to go get that and have that the bank's updated, we will do that within 2-3 days of his release or something like that. That's the question before him, not what he's answering.
Part of the agreement last fall was that Mr. Warner would continue to operate the farming operation and provide details to Mr. Holderman and Mr. Bullock, which we were doing, including the budgets and some other things, but we're happy to do that. I mean,
so he's representing there's no gamemanship going on. There's nothing nefarious happening. And last fall, there's supposedly an agreement for Mr. Warner to continue the farming business, and he would just show the accounting of it all. Whereas the judge has ordered that both persons or multiple persons are put on the account so that they can see it in real time. And same with the attorney Polderman, he's like, I want access to the QuickBooks so I can see it in real time. I don't want you giving reports every quarter. I want to see it as it's going. I want to have access as it's going. And yet, he's doing a lot of talking about nothing. but didn't the court already ask you to put it together?
So let's take some time to hear from other attorneys. Ms. Berger, have you had a look at the documents? What are your thoughts?
Yes, thank you, Your Honor. I have not been able to review every document that came in over the weekend. As you know, Judge, we did have some hearings over the weekend, so it's been a particularly busy time in my office. However, I have been able to review most of them. I do not believe that we have a budget for May and June of this year. And I did have one question as related to the QuickBooks accounts. It looks like there's a QuickBooks Online account now, and that originally those were, or the QuickBook account that was being used were related to source documents. So that software was downloaded on a particular computer and could only be accessed at that office unless those things were downloaded or uploaded to a shared drive. So I think that there are two separate QuickBooks accounts that we need to make sure that we have all of the documents for, as well as remedying any issues with invoices and being able to line those up with deposits and withdrawals from those accounts. And I do see that we have most of those documents, but I've not been able to line those up yet.
Your Honor, I would renew the invitation to Ms. Berger to come to the office and look at the source document.
What is his problem? What is his problem? The woman said you just gave it to her over the weekend. So any accounting usually cannot be done in a matter of days. You want to, so when I did bookkeeping, I would reconcile the books 1 week and then go back and reconcile my reconciliation before I final stamped it, just so that I didn't doze off and put a comma in the wrong place, put a period in the wrong place. Double check your work, right? And I would do this, and it doesn't have to be 2 weeks per se, but it'd be like one day. Usually I would do it on a Friday. So that Friday, and then the next week I'd come in, maybe by Tuesday, I would have had it finalized. That's what I mean by 1 week to another week. Just so that I knew that I had a clear head between days, so that I would start over just to make sure that I found the same amount of numbers and they found, and the other team found the same amount of numbers. And I did mine's twice, because when I finalized mine, then that was the final numbers that went in before we had any audit. So I had to always make sure that, you know, our numbers were completely tight, right? So I don't understand this man's malfunction. The woman is saying she got the stuff over the weekend. She had hearings in different matters, or, you know, whatever, different hearings over the weekend, which is crazy. She's probably, well, there's a lot of guardian ad litem, so they're probably dealing with either senior citizens, disabled individuals, or children, those who can't necessarily represent themselves on independent stuff. So maybe she's doing extra hearings relative to safety and wellness. I don't know what weekend hearing would be necessary, because I don't work in that space. Mine's litigation, usually employment law, some probate stuff, right? Family law a little bit. But anyway, and then he jumps into, I invite her to come to my, nobody wants to come to your office. Nobody wants to come to your office. If you have 2 accounts, we want you to rectify that. You need to have one QuickBooks account. We don't want to come to your office. We didn't have all day the last 2 days to look over your work and double check it, you
She's
know.
entitled to look at whatever she'd like. We'll provide it for her. We'll provide her the login password that we're providing to Mr.
Look at this. Look at the judge. She makes faces. So many judges don't. And you just don't know what they're doing and what they're thinking. But like, that's why I think I could never be a judge, because it'd be written all over my face. I'd be looking at you sideways and cross-eyed all the time. I couldn't hide a thing. So to see this judge here making faces, it gives me hope. Maybe I'll have a day that I can be redeemed.
Alderman and Mr. Bullock. There was budget submitted for May and June. I'm not sure why she doesn't have them, but if she needs them, we'll get them.
Mr. Bullock is making a
Mr.
face.
Your Honor, I had a telephone conference with Mr. Bolderman and Mr. Bullock. I had some concerns and questions. We did discuss progress, and my position is now the same as Mr. Bolderman's. Although I would like to hear Mr. Bullock's response to Ms. Berger's inquiries, Your Honor, as that was not something that I brought up.
Okay,
Your Honor, I don't know if she directed those comments to me. I think those were directed to Mr. Lieb. Although, Ms. Berger, if there is anything that you'd like me to address, I'd be delighted to do that.
This judge is a hoot. She is giving faces. She's like, oh no, you don't think you have anything to do with this, huh?
Sure, I'm just looking for clarification as to what type of QuickBooks account we have currently, and if that has been the case ongoing.
Right.
So are you asking if we have QuickBooks Pro or something like that? It's the standard commercial accounting system.
No. Don't play fast and loose. She was very clear. She said it looks like there's two types of QuickBook accounts. One is online, which if you have a business, you know that you can buy an online subscription of QuickBooks, which is usually the preferred version because it allows multiple people to just log in no matter where they are. But she says there's another one that has something to do with the uploading of source, and you have to only use a particular computer. So she wants to know, are there two QuickBook accounts or just one? And he's talking about, do we have QuickBook Pro versus, do you have two accounts or one?
QuickBook, which is interchangeable with just about any of their systems. The different types of QuickBooks really relate to the type of reporting that one does.
Perfect, so it's one account.
What is this? Yes, she made the. You see the judge. You see the. Yeah, judge. Please ask. What are you talking about, man?
Just about any of their systems. The different types of QuickBooks really relate to the type of reporting that one does.
Perfect, so it's one account.
As we sit here right.
You see this face. You see this. Miss Ariel Berger, I want you to go to QuickBooks now. I want you to understand. Go find out how talk to a QuickBooks support staffer and find out how they work. Whatever this man is talking about does not make sense. Don't make dollars, don't make sense, doesn't make sense. You may have QuickBooks that will allow you to do more things. And yes, like if you want to do a P&L report, if you want to do an aging report, different reports are allowed within different levels of subscription. But the original question is, do you have more than one account with QuickBooks? Do you have two different memberships with QuickBooks? Not what he's talking about relative to what type of report you want to do.
Now it's one account. Yeah.
Now it's one account. So there used to be two?
Things right now.
Perfect, so it's one account.
As we sit here right now, it's one account. Yeah.
Perfect. Okay.
Things are a little fluid, so it may change. But I'll, of course, as we have, I'll keep you posted, Ms. Berger.
Thank you.
Why would you need more than one account for QuickBooks? But okay.
If I might
Well,
finish up.
you might need more than one if you're going to separate the businesses. And you want to have different QuickBook accounts for the different businesses. Maybe that's why you would do it, because you don't want to confuse the bank, because when you download the bank statements into QuickBooks, then you want to make sure that you're not taking from, because it looks like it's 3 or 4 businesses, and you don't want to take from the wrong business, the numbers from the wrong business, and upload them to the wrong account. So maybe that's why you would have more than one account. But okay, Mr. Bullock, I'm gonna trust you to know what you're talking about.
Based upon that, my only thought on the Premier Bank account is that upon release, they have 24 hours to establish that. I think that's sufficient time to do that, to comply with the existing court order.
I love it. Who is talking actually? Is because it sounds like it's the guy who wasn't making sense earlier. Let me go back.
We sit here right now, it's one account. Yeah.
Perfect. Okay.
Things are a little fluid, so it may change. But I'll, of course, as we have, I'll keep you posted, Ms. Berger.
Thank you.
Ms. Wilhelm? Oh, Mr.
If I might just finish up based upon that, my only.
Oh, okay. So it's this gentleman here. So it's not the guy who was representing everybody has everything, because he was giving me fluff. This gentleman here is now brought it back to the true issue that Mr. Polderman brought up, that there is a current judgment, a current order that is requiring that everything be in the Premier Bank account. And so when the judge said, well, how are you going to rectify the fact that everything is in Mr. Warner's name and it's supposed to be, in the right account? He goes into that long fluff about, oh, well, whatever you want us to do, we'll do. The reality is she's already told you what to do. She put it in the order. And so this gentleman goes into saying, okay, within 24 hours of their release, they should be able to get this done. Remember, I was saying maybe 2 or 3 days. So he's saying 24 hours, wants you to go ahead and get the right accounts
Only thought on
open.
the Premier Bank account is that upon release, they have 24 hours to establish that. I think that's sufficient time to do that to comply with the existing court order.
Ms. Wilhelm, your
I love the emphasis of to comply with the existing court order, because you don't need to give me a new order, Your Honor. We're sufficient with the one you gave us last time.
position?
Yes, Your Honor. I did have time to review the documents. All of the documents. I'm not an accountant. I did not dive deeply into those. I respect and go with this conservator's response in this matter. And I did have an opportunity to speak with John Polderman today as well for questions that I had about the documents. He answered all of my questions, and I will go with whatever that they recommend here. And I do agree with Mr. McFarland, though, that the accounts do need to be, the account does need to be set up, or as Mr. Polderman pointed out,
Freedom.
accounts do need to be, the account does need to be set up, or as Mr. Polderman pointed out, Mr. Bullock needs to be added as onto the account so that he can have free access to whatever accounts are being used.
Okay, so this is where I took. So as much as this attorney here flustered me, he really flustered me as time went. It wasn't one particular thing. It's just kind of like the way he was going throughout the whole case, or the whole hearing, I should say. But I guess, like I said, he's probably more than anything just trying to defend his integrity and hopefully represent his clients in the best way that he can. I take absolute issue with this lady. She has really disturbed me because she, I believe, is a guardian ad litem. So I presume that she's in representation of a child. Who knows? But she's standing in representation of one of the beneficiaries. And her response to understanding the documents before her is, I am not an accountant. I looked at it for as best I could. And I have leaned on the understanding and representation by the other attorneys, which may or may not share the same interests as she does. I guess she's sitting on this side, so this gentleman may in fact have a direct correlation to what her client would have. But this is where, if you have the ability to have your own trust in place, what you do, because you can just do it, right? But let's say you just don't know who you're going to have to be your guardian ad litem for your children if they're underage. I would implore you to just really work with someone. Work with them, have them to know your children, get them to understand what your goals are. And for whatever they don't have the ability to do, if they're not an accountant, if they have an accounting question, they need to have access to an accountant. Share with them who you think would be a good CPA to run things by, to get a professional opinion of. If you find yourself, you just have a list of resources in general. Here's the insurance person that I'm dealing with. It's in the trust. You can even put your real estate agent in the trust. If you're going to sell any real property, use this particular brokerage, use this agent. This is important. Your items are important. So you want them to be covered and dealt with in the way that represents your best interest and the best interest of your beneficiaries. And I am very disturbed by this lady's representation that she's going to default her judgment to someone else's understanding who is not hired by her, but yet could in fact be in representation of another beneficiary. It may not be all that bad. Maybe everyone is kumbaya and everyone, is able to trust each other. But in the instance that they don't, or even if they do, I want you to represent this particular individual or individuals, whoever she's representing. I want you to represent them independent of the others. I want you to be able to have the accountant on call to say, hey, I got all these documents. They look like they add up to me. Do you see anything wrong with them? Can you do a sweeping review? I have court on Tuesday. I need to kind of represent to the judge if I have an issue with these documents or not. Now, I understand everyone's scrambling to make heads or tails of them, and they can say, yes, we have representation. We can represent that we have these documents, but please don't come to court and tell me what you are not, versus saying, I personally am not an accountant. I have reviewed them. I've talked to, colleagues and whatever, my co-counsels or whomever. And I've also commissioned a CPA to look at them and to give me a better understanding. I reserve my concerns for a later date. If I should need to bring it up to your honor, I will at that time. But right now, from what I can understand, I don't have an issue, but I will be in further review of it. I don't know. I just want you to fight for me. Fight for mine. Don't just give it away.
If the court gives a little bit more time, I don't know how quickly my clients might be released from jail, but my guess is that tomorrow morning may be a little more difficult than, say, Wednesday morning.
Okay, so this is Monday.
Or Wednesday morning.
24 hours is 24 hours. What are you talking about? But whatever.
All right, well, I want to acknowledge that there has been a significant good faith effort made to comply with the court's orders, and that's, I'm sure, due much of thanks to Mr. Leave's efforts, as well as the people working to sift through those documents and produce those documents. And the lion's share of what needs to be produced does appear to have been produced. That being said, the access to the QuickBooks would appear has only been granted up to last March. And the court's order specifically is engineered to encourage the release of all documents around the farming operations, and those QuickBooks records are exactly that. So we will need to have compliance with the court's order in that respect, as well as I'm sure it's just simply a matter of ensuring Mr. Folderman has had the right link sent or access to him for those legal invoices. And then we'll need to hear a plan. And perhaps, Mr. Lee, you could take a few minutes after today's hearing and work with Mr. Folderman, Mr. Bullock, and the other attorneys, if they have a few minutes, to talk about what the plan will be in order to bring either compliance completely with use of that Premier Bank account, or an alternative that we can then put in place through another court order to allow Mr. Bullock access to all funds that are associated with the farming operations. So that being said, I acknowledge your progress, but those three issues will need to be remedied. I'm happy to review this again before court begins on Wednesday morning. We could set this for the 8:30 a.m. time slot and just look at this before we get into the hearing on Wednesday morning.
Your Honor, may I say something, please?
No.
Mr. Weisberg, I would suggest that you consult with your attorney before you decide to make any statements today. But I'm happy to make some time for you to do that after a hearing is concluded.
Well, I think it pertains to your decision
No,
with the documents that Mr. Polderman is looking for.
no.
I think an easy remedy can be given right now to the issuance of all of the Smile a Mile invoices with access to the online QuickBooks program. So he will have access, he could look at all of the invoices online without having to actually see, get the copies of them. He'll have access, he can print off all his own copies. And then.
All right, okay, Mr. Weisberg, I can appreciate what you're doing and how you're working, and I think that's great. I don't think that that's part of what we need to do during the hearing today. So what I'm gonna do is I'm gonna conclude the hearing and recess, and I will just leave you all in the Zoom room and in the courtroom if you wish
Your Honor.
to discuss what needs to be discussed to secure compliance by Wednesday morning.
Your Honor, I believe we've complied with everything pursuant to the order. I would ask my clients to be released so that at least we can set up the bank account. I mean, I can't do it without that.
I appreciate your concern, Mr. Lee, but I've been very clear in my expectations. And I'm hoping very much so that you'll have those remaining
That you
three
can hear.
issues resolved by Wednesday morning. It's my hope as well that your client will be able to.
Okay, so I guess court got cut. I don't know what happened to the end of that hearing. But yeah, I don't know, is he falling asleep in court? Like, what's the problem? Because she said these are the three outstanding issues. She itemized and then went to, say you can remedy these things now. We'll take a recess and you can go ahead and remedy these things. The attorney, no. The client who just began, Weiserman, I think it was, or something to that effect, who just began giving like, oh, Your Honor, maybe we can do this and maybe we can do that. No talking. No talking. No talking. Come on, let your attorney do the talking. First of all, what he was suggesting was already what Mr. Polderman asked for and what his attorney said he would do. So yeah, they kind of addressed it. But then the other thing is you might find yourself saying something you don't really mean to be saying. Okay, so they're back from court. They're back from recess now. So we'll go ahead and look at that. Make sure to note, this is going to be loud, okay? I'm turning the volume up because, like I said, there's variance in volume settings between each speaker. So please keep your ears protected, unplug, turn down your volume, whatever the case may be, so that you can hear your loved ones talk to you tomorrow, okay? I don't want you to go in deaf trying to hear court.
2CA. We are back on record for a review of the contempt that was rescheduled from the other day. May I have the names of our participants, please?
Suzanne Wilhelm, guardian ad litem for Angelina Warner.
Morning, Your Honor. Ariel Berger here is the attorney for Dee Warner.
Michael McFarland, attorney guardian ad litem for Dee Warner.
Larry Lee on behalf of Dale Warner and Mark Weisberg.
Good morning, Your Honor. John, on behalf of the successor conservator, Charles Bullock.
Okay, and from the jail?
Dale Warner.
Mark Weisberg.
Thank you. All right. There were three specific things that the court was looking to address as a result of the last review. Mr. Lee, would you like to introduce any evidence in compliance with that order?
They're in the same.
Morning, Your Honor. Larry Lee on behalf of Dale Warner and Mark Weisberg. Since we were in court on Monday, the court requested that we produce three items. One was QuickBook access for Charles Bullock. We did that
Okay, so they held a recess, I guess, for the 2 days. So now they're here at hearing on Wednesday. So this is a couple days later.
Through his attorney, John Polderman, we provided copies of the logins and their acceptances that we circulated amongst the court and all the attorneys and all the interested parties. Next, the late law invoices were to be provided. They were provided previously and were again provided again on Monday, just so that everybody had them. Third, there was an issue regarding the bank account. In court, the court mentioned the Old National Bank account. Jaron Warner, who is Mr. Warner's son, who is a power of attorney, went to the bank yesterday to add Charles Bullock's name to the account through a power of attorney. In order to conduct the transaction, though, because they are business accounts, Mr. Warner must be there physically. I have a letter from the bank to that effect regarding all of the accounts. It's been circulated to the court, the attorneys, and all the interested parties. Lastly, in yesterday's order, there were some comments about a premier bank account for Warwick Farms LLC. That account was closed 9 months ago by the Michigan Unemployment Agency. They garnished the account to zero. The bank account was then closed for no activity. I can report that as an officer of the court. My understanding is that Mr. Polderman subpoenaed those records and received a subpoena response to that effect. I have spoken to all of the attorneys this morning. All of them have confirmed that Mr. Warner and Mr. Weisberg are in compliance with the court's contempt order from last week and the continuation from Monday. I would ask that they be released forthwith. Mr. Weisberg's daughter is getting married this weekend. He should have spent the last few days preparing for the wedding. His daughter and her fiance were due to meet with them to finish things up and get ready for the wedding on Saturday. And having now complied with this court's contempt order, I would ask that they be released forthwith. Thank you.
Okay, let's go to Mr. Polderman.
I do believe what Mr. Lieb said is correct as far as the production of documents.
Sorry, guys, let me take this back.
Okay, let's go to Mr. Polderman.
I do believe what Mr. Lieb said is correct as far as the production of documents. I do also think, though, it's critical that Mr. Bullock be on the bank accounts forthwith. It does seem that Mr. Warner has to be present to do that, or they're looking for a special order from the court. So my only request is that before the end of the day, and I think Mr. Lieb has agreed to prepare this, or I can certainly prepare it too and circulate it to the parties, is just an order that authorizes Mr. Bullock to be placed on the account. So Old National has that. And then as a condition of his release, that Mr. Warner immediately go to Old National Bank with Mr. Bullock and have him added on the accounts so that doesn't get lost in the shuffle here.
Your Honor, that will not get lost in the shuffle. I spoke with the woman who issued the letter yesterday at the bank, and the requirements were very clear, and I asked her to put it in writing so that I could supply that to the court as evidence in that conversation.
Okay. But didn't you just give a nice soliloquy based upon your client supposed to have spent the last couple of days getting ready for his daughter's wedding? So he has things to do, right? Because he was supposed to have the last couple of days to do it. So he has to make up that time because he's been in jail for lack of compliance with orders. This is kind of why you follow directions, right? You follow the court's orders so that you don't miss precious time with your family, whether you're doing nefarious criminal activity or you're just doing simple non-production of discovery. These things can land you in jail when you don't follow the court or the law. So yeah, he still has time. I mean, what is he, get a haircut? Like, I don't understand. Maybe he had to go for his last fitting for his suit or something like that. But the attorney just made a whole big deal about he has missed out on some very precious time relative to his daughter's wedding. And now when the opposing counsel makes a note of that and says, okay, understanding that he has a lot of things to make up on his timeline and his schedule, I don't want this to get lost, Your Honor. So I need another order. I need this to not get lost in the shuffle. You want to come and be defensive. It won't get lost in the shuffle.
So there will be no gamesmanship, no misunderstandings. Mr. Warner will go right to the bank and end Mr. Bullock's name.
Comments from our other attorneys this morning?
I have nothing additional, Your Honor.
I support Mr. Polderman's position, Your Honor.
I have nothing further, Your Honor, and I support Mr. Polderman's position. Thank
All
you.
right, thank you very much. Okay, Mr. Polderman, if you want to draft and circulate an order requiring Old National to put the conservator's name on those accounts and obviously let Mr. Lieb know if you need any specific information for that purpose. I do find otherwise that it would appear that the parties have brought themselves into compliance with the court's orders and thereby have officially purged themselves of the civil contempt with the exception of that last and final piece. For practical purposes, obviously, we have another hearing set for today in the matter 22-52433 ML. I would like to offer in the name of judicial economy, as well as for an opportunity for Mr. Polderman to circulate that proposed order, that we simply recess on this particular matter in the CA matter until approximately 11:30 or sometime around lunch, and then we'll go ahead and effectuate the execution of the order regarding Old National, as well as an order from this court documenting compliance with the court orders, and then effectuate the release of Mr. Weisberg and Mr. Warner so that they could join us in person for the proceedings this afternoon. Mr. Lee.
Your Honor, if Mr. Polderman could just simply draft the order and email it to Don Powell this morning, we could certainly look at it in the next few minutes while we're waiting for Mr. Flood
That space.
to get here.
Oh.
We need to wait till 11.
I love her so much. Oh, Kathy, Catherine, can we be friends? Oh, her faces. She has the tea for days. I just want to sit and have tea and crumpets with her, and she just tell me all about what is going. I got to call my judge friends because you know they can talk. They can't tell me which case what, but they can give like juicy details. And we can little gossipy things. Like I just really wanted to hang out with Kathy and be like, tell me about it, girl. Just tell me about this face right here. What are you standing up talking about? She just said we're going to have a quick recess so he can circulate it and then we'll come back. He's like, no, let's do everything right now. Right now, Your Honor, right now. Okay, I'm sorry. You should have had that type of gumption and commitment to excellence when she put the order in the first place, instead of having them go into contempt because you want to play fast and loose and be all slow-witted with it. You should have had that type of timeline of the right now feeling that you have right now. That's what you should have had back then. Then they wouldn't be in jail at all. You wouldn't be having this argument.
Oh, hello, Mr. Flood. Thanks for joining me. Sure.
What?
Wait till 11:30. Oh, hello, Mr. Flood. Thanks for joining me. Sure. Thank you.
All right, very well. So we'll recess in the matter of the 21-1-51852 CA matter for the time being. Mr. Polderman, when can we expect to see that proposed order?
It's being drafted right now, so I would imagine I'll have it circulated in the next half hour to 45 minutes.
Very good. Let us know if we need to take a little break.
Oh my gosh, she's my new best friend. I don't like whoever's working her camera because they're cutting it off too short. We like to see the end of court. When we come to court, we want the full court experience, okay? We want the beginning, the middle, the end. Stop cutting me off at the end, but it's okay. At least they're broadcasting, right? Not every court is, so we're grateful for that. Okay. She is like my new bestie. You see how she did that? He jumped up and said, we could do this right now, and he can circulate it, and then we can all look at it, and then we'll come back and this is what she just said. It's just exactly what she just said. You're adding nothing to the conversation, and she doesn't entertain. She's okay, thank you. So, Mr. Porterman, when can you have this done? Okay, we'll be back. It's such a, like, she totally runs her court without the other gentleman's input. She allows him to get his talking point off on the record, and she maintains it. So, taking a look at my note here. Okay, so they maintain they're going to maintain with the old National Bank, which sounds like to be the original bank. They're not switching accounts. The order had said to put it in the Premier Bank account, to open up a whole new account in a different bank. But they're sticking with the old National. If I were Mr. Polderman and I had concerns, which he seemingly is presenting that he has a set of concerns relative to the accounting practices, or at least to the to some of the some of the reporting on the accounting. You know, maybe the accounting is fine, but they're not getting the access, and you know, he just wants to have some better faith explanations and understanding of the way the business is being run and how it's being accounted for, the financials. The conservator, Mr. Bullock, sounds like he's the financial conservator, because they seemingly want to, so maybe he's a CPA, because they seemingly want him on all things financial. Like they want him on they were talking to him about the QuickBooks. They want to understand his reporting, and then they want him on the actual bank account. So I believe he's the financial conservator. Well, I take issue with not getting a new bank, and I'll tell you why. Because the new bank would have a new slate of relationship with all of the parties that are going to be on that bank account. Whereas the old bank has an old relationship and has already have some familiarity with the original account holder, right? So sometimes having a good relationship with your banker gets you different perks. Maybe you're not standing in line for certain things. Maybe they'll give you, they'll give you extensions on, loans, or they'll work with you. Or if your account is, if you need to check the deposit to clear faster than usual, they'll work with you when they have good long-standing relationship with you. And I just don't know. I mean, I don't know what their reason was to have the new bank, but hopefully it won't bite them in the butt, because whoever the new person is on the account may not get the same amount of respect and love. Hopefully that won't be the case, but that was just something I was interesting that they maintained the old bank. Yeah, and I didn't like I guess I'm just kind of, he's under my feathers already. Mr. Lee, I think is his name. Whereas he is like always trying to prove that they are not being nefarious, when in fact something is just not right. Maybe they don't intend to make wrong steps and missteps, but something wasn't happening in accordance to what the court had put into place in the order. But this is a very good look. Okay, so today's case, we took it on both days, so we got a good conclusion relative to this particular hearing. This was a good case to kind of see what some of the things that happen. And just think about this. I think there's 6 attorneys / conservators, guardian items, right? There's 6 professionals getting paid for their time. Okay, that's the way to look at it. 6 professionals are getting paid for their time to come before the court every time they have to come to review documents, thousands of documents, according to representation of Mr. Lee. And whether the attorneys are going to his location, so that's travel time, or they're reviewing it in their own location, and they're going down to the courthouse and the travel time for that. There's so many expenditures relative to this one particular hearing. And this is something that is avoidable, because this is, you didn't do something, so therefore this is the court's reaction. It's not as if it's just, any particular hearing of like a status conference, or you got to update the judge on a, just status of the case. No, this is, hey, judge, we have an issue. Here's the issue. they're not complying. Oh, okay, well, make them comply. Oh, guess what, judge? You put in the order, they didn't comply. Okay, so now they're in contempt. And so this judge, I really like her style. She reminds me of Judge Middleton. Very kind of even keel with it. It's just like, yeah, just say whatever you want to say. But bottom line is, it's going to be whatever I say, right? I'm still the judge. You're just you're talking. And in a lot of instances, he's like saying what she said, or even his client is turning around and saying what's already been said. So there's a lot of echoing of the same spirit. So she lets it ride a little bit, and she just goes ahead and keeps running her court and doesn't miss a beat. So I really enjoy that. I hope you've learned from this. This is the time where we say, okay, what can I do in my situation, taking away from this? Well, like I said, when you're interviewing your administrators, when you are thinking about having a guardian ad litem, if you have small children and you're designating those persons, talk to them a few times, give them the lay of the land of how things work. Make sure you give them a resource binder of contacts and information of individuals that can be helpful through the process. If you have them already selected, if you don't, work with them to kind of figure out, well, who should we have to do this and that? Who should be our appraiser, do our estate sale? A lot of times you can get that from your real estate agent. Real estate agents are a great resource. Okay. Realtors know a lot of people. Okay. And that's what we do. We hook you up with different resources, moving companies, estate auctioneers, different ways that can be different companies and different liaisons, the things that can be a great resource to you and the administrator of your trust, so that they have some direction. If you, like I said, we have a complicated trust. Now, another thing to think about is there are a lot of businesses involved, and these are two men that seemingly are in representation, and then there are some conservators and guardian ad litems. That could very well be the death of the third owner, maybe. And consequently, his family has a share. And instead of dissolving the business, they take on the ownership. They replace, the trust replace his participation. That could be the scenario. It looks like that's what's unfolded. The other thing that you could look into with a business attorney, you can look into business, what's it called? Business partnership insurance. And what happens is you can insure each one of the partners so that on the event that one of the partners passes, instead of ownership continuing with the beneficiaries of your trust, they get paid out, right? So upon your passing, the business pays them for the payment of your ownership. So that's another way that you can work on dissolving. So you want to talk with your business attorney to see what happens if one of the partners pass, what can keep the legacy moving forward without having to deal with the family members or the beneficiaries of one partner versus another, because that sometimes can be messy because not everyone has the same goals that you once had as a partner, right? So you might just want to pay them out. That's something you can look into. And I think that's kind of where we are here, that there's like 3 partners or 3 owners, and that one of them may be deceased, and so, or at least under a conservatorship. Maybe that's why there's so many conservators. Not really sure the beginning parts of it, but it does let us know that there are possibilities. You don't have to continue on, or you can continue on. Just whatever it is, make sure that you have an agreement with the partners. And in this instance, it does bring upon a lot of issues with making sure that everyone's informed, everyone's on the bank accounts, everyone's looking at, all the financials. It could very well be just to get a very true and correct understanding of what the valuation of the property is. That could be the reason. And then they'll pay him out later, pay his heirs, his beneficiaries out later. That may be the reason why there's so much activity, because probate does not want to be in perpetuity. They're not looking to oversee this particular matter forever and a day, right? And of course, businesses have their own identity. They have their EIN number, which is much like a social security number. They have their own business license. These are like their IDs. So they are usually treated as individuals. The corporations are treated as an individual. So they want the individual corporation to live as long as possible, to continue long after the starters and founders, right? So the court doesn't want to be involved with the business side of that corporation forever. So it's good to have the insurance, or at least an exit plan. So I'm not sure how this case is going to exit, but for your purpose of learning and for us to take away knowledge, it gives us rights to say, you know what, I have a business. Let me go talk to my business attorney and see what if we would dissolve, if that would be a best interest, or, how we would split it for the heirs. What do we need to do when we're formulating this in the trust? Do we get just the insurance? The heirs get the money from the insurance, and then we let another entity run the business, or another partner run the business and keep the business going beyond us? Nonprofits are ran by the board. So maybe you put you can do a board for the for-profit. So maybe you put a board over it, so it governs and keeps the business rolling and running. And it's long after its founders, and it's still continuing on. So there's lots of things that you can look into. So if you have a business, talk with your business attorney. So right now, all of this is suggestion, right? I'm just suggesting things, not telling you what to do. It may sound like I'm giving you advice, but I'm not. I'm making suggestions. You should let professional people do professional things. Okay, that's what we do here. We talk to our professionals, and we realize that everyone can be different. We're not all the same. So we might talk to the same attorney and get two different outcomes and two different pieces of advice. So don't take someone else's advice and think that curtails to you specifically. It's just learning about what possibilities are out there, so that when you go to talk to your professional, you have a basis of your questions and some ideas of what you might want to do. I would love to represent you. And in order for me to do that, we have to have a contract. So let me know if you need me. If not me, or you need some representation from someone else, I can always refer you to others. But I am Lyric Armstrong, your real estate agent and advocate. I am happy to serve you. Thank you guys for all your love. I've been seeing the activity. You guys have been doing great things. Don't forget to keep up YouTube things, like, share, and subscribe, because that which you know is wonderful, but maybe someone doesn't know and they need to know. So share it out there. Let's keep this information going. You saw, we were looking at probate court. There's 6 likes on there. There was something, 10 different views, and the information is priceless. We won't be able to correct it when we're gone, right? So let's find out what's going on now, what we can do now, so that when we are gone, our heirs and our beneficiaries can say, oh, what a wonderful person that was. What a lovely corporation that was. They thought of us. They tightened up everything. Their trust was in order. I didn't have to go to probate longer than 90 days. Like we just showed everything was everything, and we're good to go. Let us keep our house in order. Okay. So once again, Lyric Armstrong, your real estate agent. Don't forget to like, share, and subscribe. Talk to you later.